Start our open discussion of the constitutional reform. We'll be talking about justice, about how this will affect the system of national justice and national legislation. I would like to welcome the speakers. All of them are the members of the Constitutional Commission and one observer. These are I will introduce all of you. Oleksandr Volkov, Judge of the Supreme Court of Ukraine. Serhiy, Holovatyi, Member of Constitutional Commission. Andriy Kozlov, Coordinator of the Project Support for Open and Democratic Reform Project in Ukraine, the Democracy Report International. Bogdan, Lvov, Judge of the Supreme Economic Court of Ukraine, and Mykola, Onyshchuk, Doctor of Doctor of Sciences, Head of National School of Judges. So please speak briefly, and we will start from you, Mr. Holovatyi. The first question is to you, and it's very simple. What is the constitutional reform about? What will this change for the domestic justice? So what is the constitutional reform about? The newspaper Юридичний Вісник, which is one of the latest issues, the 6th of November, professional newspaper, a big portrait of the government official, Deputy Minister of Justice, the reform of justice, full reloading of judicial corps. That is all that the reform is about. Another publication, it's about journalists. 9th of November, also fresh issue. They say that almost the year fighting instead of the working group of Constitutional Commission finished with the victory of the deputy head of administration of President Filatov, Holovatyi, and Romaniuk. They were for reattesting, but at that time the Prime Minister, the Minister of Justice Petrenko, reanimation package of reforms, is there anyone from that? And others wanted to dismiss all the judges. So I would like to start from that. It's very primitive. I would say probably especially populistic presentation of the systemic reform by some, I don't know, political groups, and presentation by journalists, because that is something which will be perceived by the society. To shoot everyone, everyone to the garden. We will destroy to the foundation and so on. That is what the society does understand. What happens in fact, the reform in part of justice. So even Ukrainian terminology, justice and judicial reform are different things, because practically the Constitutional Commission has developed the proposals as to systemic reform and creating new constitutional foundation for the new system of justice. And that is what we don't have today. But how can it appear if Verkhovna Rada is not supporting that? It will be created because the result of the work of the Commission is the product which has the following ideology or philosophy. In the general part of the Constitution, the first section, there are two principles. First, principle of distribution of power. The power is distributed into legislative, judicial, and executive, and all of them are to be independent. Till today, we don't have independent judiciary. Because of one reason, I will not enumerate all of them, because in the process of its forming and functioning, political institutions participate. The President and Verkhovna Rada, politicians, they decide who to dismiss, who not to dismiss. These are all bargains. That's political process. If political institutions are involved into judiciary, then there's no independent judiciary. That's one of the elements. The second one is the principle of the rule of law. The only institution which could ensure the rule of law is judiciary. That is why the set of reforms developed by the Commission has all the systemic institutions, because rule of law, that means institutions, mechanisms, and procedures which will ensure the ability for a person to be to have dignity. So we need new institutions, new mechanisms, and new procedures to ensure that the person has dignity, because as the UN declaration says, so that the person doesn't have to get to uprising, then we need to ensure the human rights. Here we had uprisings because there was no institutions, mechanisms, and procedures, and that is why we call the revolution of dignity. So my colleagues will add up what new institutions, mechanisms, and procedures, besides the fact that the quality of a judge, the status should be different, the access to the position of a judge, training, new qualification requirements, new level of responsibility, narrowing down the immunity, because the political body is participating, it should be narrowed down to just functional. Only the Supreme Council of Justice will just give the difference. What's the difference between political and functional? You know, I talk a lot. As a professor, I can speak long, especially at the International Law Department, where people would study from Latin America, Africa, Asia. That's very interesting. So here's the judge, a new quality before he is appointed and till he is dismissed. The Institute of the lawyers. There could be no justice, fair court, if the person is not guaranteed the proper defense, and that could be provided by professional lawyer. But we don't have a professional bar association. The lawyers carry envelopes, and that's not what the profession is about. You have to be trained as a lawyer. There are certain requirements to this profession, and that's the novelty of that system. Prosecution office. Do they train to become a prosecutor here in Poland? You need to study for 3 years to get access to that position. In our reform, the Institute of Prosecution Office will be desovietized, because we take the functions of the prosecution will be just according to the resolution of the Parliamentary Assembly of the Council of Europe, recommendations of the Council of Ministers of the Council of Europe, and that is only exclusively the sphere of criminal justice. Executing judgments, we know where this execution is, how execution works. The new system, the reform of the whole system of justice now makes this responsibility of judiciary. People come to me for 3 years. They want to get interpretation of the court how to execute it. There is a renewal in the rights, but the person cannot receive pension for 3 years because they go to courts with the request to interpret how to execute payment of pension. That's nonsense. Constitutional jurisdiction. It's part of justice now. This is not the system of justice. We take it out of the justice sphere, and this will mean higher constitutional requirements to the Constitutional Court. The requirements which should be similar as to European Court on Human Rights. And we strengthen the individual defense of of persons. Now you can come with the claim not just to European Court if the Court of General Jurisdiction applied the law, and that law in the opinion of a person who defends his or her rights, believes that it's not constitutional, they can go to Constitutional Court. In Ukraine, we have a preventive system. So first the national system has to defend the person. So I will not describe everything else, but even that is enough to demonstrate how systemically the Constitutional Commission comes to what is required by the foundation of the civilized Europe. We were in the charter documents of the Council of Europe, or European Union, and Lisbon Agreement. And they say that they are built on the values of human rights, democracy, and rule of law. That is practically what the philosophy of the draft law is about. The structure of it and material content of the mechanisms of how to do that. If you exclude the President and Verkhovna Rada from the mechanism of forming the judiciary, then this will be the mechanism which allows the judiciary to be independent. So, to take it only to, in public discussions, especially on TV, to take it only to this issue of large-scale reform, to take it to the issue of re-attestation that is non-professional and non-responsible. That's very populistic, that's primitive, that harms the idea of the reform. And the rest of the sectors and other things, I hope the colleagues will talk in more detail. Thank you, Serhiy.
I would like to invite you in the order of your own concern and to start probably with Oleksandr. The only one thing I would like to ask you is to tackle the issue, the following issue. Serhiy Petrovich already mentioned the constitutional reforms and judiciary system. I would like to speak on new laws, and this constitutional reform calls for what in fact changes we would do to the old legislation according to the new constitutional changes that were proposed. And again, the question there was outshaped by Serhiy Petrovich as populistic, but I represent mass media, so this is an issue of reboot of the judge corps. So what will be with the judges that were appointed recently? What will be with the judges that have the lifetime appointment? What will be with the judges? What will be the function of the judges in constitutional courts? Good morning, dear colleagues. Several days ago, I came back from Latin America, from the World Congress on the judge education. What is the major conclusion of representatives of judicial systems mentioned? New demands, new requirements to the judge in modern world. Of course, if the activity of executive power and parliaments is rather stable, nothing new. But when we are speaking about a judge in modern world, the new and higher requirements are being put to this judge. Not only it's the issue of qualifications, but he must have a chain of qualities that must not only support his decision making in specific case, but it will be different approach to a new concept in understanding of the human rights status. In fact, today the Judge Corps verified the entire judiciary system. This conclusion goes nicely into a puzzle of the challenges Ukraine is facing now, speaking on the fundamentals, structure, principles of judiciary system. First of all, in 25 years of independence, Ukraine realistically understood the necessity of constitutional reforms in judiciary system. We must have the integrated understanding of the goals of Ukrainian judiciary system. First of all, the opportunities for legislative changes or modernization, and this has already been expired, means we're speaking about the status of judges, organization of their activity, because the ordinary legislative measures has already been expired. We've already completed all of them. And the next movement of our country towards towards justice, unbiased justice, is limited, in fact, because of a lack of constitutional changes, because the constitutional environment in Ukraine is regulated by constitution immediately, which is access to the profession of judge, and you know that constitution gives you answer on that. With the change of qualifications and some other requirements to the judges, specifically the changes of job history or career, years of career, and age, competitive approach, and putting into the exclusively competence of the judiciary bodies, judiciary agencies, the issue, the question of competence of judges. Those are changes that are provided by the would-be changes. Next proposal, the suggestions proposed not only limited by a question of reboot or certification of the judges. If we say replace 100% of judges, which is theoretically even is not possible, but at the same time, if you do not change the entire system of functioning of the judiciary system, this positive result will be nilled and void, and we must change system or we must change the judge. I believe this is not a proper contradiction, because we must change both, and we must come to a new quality of the judging itself, of any judge. And those visions are laid in foundation of the proposals of Constitutional Commission, and the subject of constitutional initiative is Mr. President, and well known that this opportunity is in the range of responsibilities of all the 150 deputies, people deputies, but not a single political power succeeded in development and a way to implement constitutional constitution initiatives. That's why I would like to announce this thesis immediately. The only one subject that could push this process ahead in our country is Mr. President, who created this Constitutional Commission, and via the tools of constitutional process means discussions, we may move the changes. Next thesis, dear colleagues. The changes to the Constitution are of complex, are of integral nature, and they are dealing with all the reformative steps in judiciary area that means the reforms in justice. We are not speaking only on judge as a person or institutions of justice, but we are speaking about prosecutor's office, and the understanding of what it is, the prosecutor in the judiciary system. Nobody has already understood this. We are speaking about reforms in the advocate or bar, the advocate corps, which may lay foundation in increase of professionalism, means increased quality of the services. Again, we're speaking about the execution of sentences. We are speaking here about the means of reforms in constitutional justice. Mr. Holovatyi already mentioned that. Means reconsidering of court decision with view of constitution. So all those changes to constitution deals with the entire spectrum of relations that are laid in the judiciary field. Everything I mentioned here allows me to conclude that there are certain expectations, we have grounds for that in constitutional changes we will lay down the real foundations of for realization of expectation in our society to revive their trust to judiciary system. Again, using this opportunity, and we do not have politicians here, we have society or representatives of our society here. Now we have a time when issues of how to make changes and amendments to judiciary system, to justice, should not be the subject of, say, speculations or political tampering. It is obvious that this is a unique chance to make really important step in order to establish new foundation of the judge status, judiciary system that should support the Article 6 of European Convention on Human Rights, clearly saying that everybody has the right to have fair proceedings of his case by unbiased court that is established by law. And finally, the last thesis deals with the following. Constitution Commission comprised by representatives of professional community, experts, judges. This Constitutional Commission, its work was rather transparent and open. As an evidence, this is our two-day discussion, and all the proposals were put on the table, and each and every thesis was discussed, of course, somebody has some other vision, but this is the essence of transparency and openness. You should be heard, you should be convincing in order to do something. So we have a unique chance today in order to put aside the political preferences and to do a step ahead in Ukrainian as a nation. Ukraine as a nation. If we take as an example of Brazil, Brazil is rather good now in development. Why? Because they achieved the independence of their judiciary system. They have a lot of cases, corruption cases for senators and high officials. This is a good evidence that of the role of judiciary system in the progress of a nation in sense of society. So we will do this very important thing to the interests of Ukrainian nation.
Mykola Onyshchuk is director of the National School of Judges of Ukraine. Now Bogdan, Lvov, head of the Supreme Economic Court of Ukraine. I will try to be briefer, but I would like to mention that I would like to sort of negate three very serious myths. First, the judicial reform is the same as introducing amendments to the Constitution. No. The judicial reform is not limited by introducing amendments to the Constitution. Introducing amendments to the Constitution, probably the most important but purely strategic part. It will not address all the problems. It has to identify the directions of the development and remove all the obstacles which are present in these directions now. That is, I will not repeat, but I have to indicate that this is really about political influence, about economic influence, financing judges, also ensuring the quality of judicial court. That is about increasing the role of the judges, but also it's about ensuring the main objective of the judicial reform, achieving the transparent and just ruling. The second myth is that the judicial reform is not limited to structural changes or changes of the judiciary, of the judges. That is strange when, unfortunately, Ukraine submits to the Venice Commission, to international experts which have to help Ukraine create what it wants. They give two proposals about 2 levels, 3 levels, or whatever. The discussions were very active during many meetings of the Constitutional Commission, but I would like to mention that that does not matter. And when they are trying to say that 3 levels will speed up the consideration of cases, I'm sorry, we have our own experience. We have the story of 2006, 2007, when after the appeal consideration, there were 3, 4, 5 years. It would take 3, 4, 5 years before it would be considered by the Supreme Court. Now, someone theoretically decided that if we liquidate this court, then the terms will be liquidated. No, 3 higher courts, Supreme Courts, consider 180 to 200,000 cases per year. Everyone practically about 50,000 judicial mistakes are committed a year, which are corrected by the Supreme Court. The Supreme Court cannot correct all these mistakes. They can consider 10, 12,000 cases. And if we artificially remove that third level, that means that we will deprive these 50,000 people a year the right for judiciary. Of course, we can make the judiciary fee very high, but this will not resolve the problem. The number of cases should be reduced in the result of passing the laws, because the laws which are not supported by money, and we cannot pass populistic laws which the state cannot finance, but they are passed. In future, execution by the civil servants of these laws, that is again important issue. At the same time, the procedures of mediation, arbitrary, are to be implemented. They should be efficient, cheaper than addressing the court, but during some time they have to gain trust from citizens. It is impossible that today we throw out these cases from the court and tomorrow we'll be looking for ways how to resolve them. So without suggesting alternative procedure, we cannot take these cases away from courts, because then we deprive our citizens of the right of judicial protection, defense. So then structurally, also many ideas are expressed everywhere. Specialization takes place in such a direction. Specialization of judges within one court, the next stage, higher specialization, that is specialization with the judicial chambers or collegiums, and the highest level of specialization is creation specialized court. It doesn't matter whether it is military or on issues of IDPs or on defense of the veterans of war. Not a single country of the world has an experience when during decades money would be put into specialized courts and then these courts would be eliminated. No, we even taking the example of district hospitals, you will understand it better. It's a great idea to have in each district hospital the best specialist in each section. But is it possible? It would be great, but is it possible? You know the answer. I'm happy that the Venice Commission supported the idea of specialization, especially mentioning administrative courts as the courts which turn their faces to physical persons first of all, and the third myth is that we need to wait for judicial reform. We shouldn't be waiting for it. It's taking place already. In February that year, the law on just court was passed. The procedure of competition, attestation, assessment were introduced. They are efficient, but we have to understand that exclusively the law, it is impossible that today we pass the law and tomorrow we have the result of how it is applied. Any law is to be implemented during some time, and we will not have to wait for decades. We have such a result as if the judiciary core has not didn't get rid of those people who have to leave it, but the Supreme Council of Justice was created only in June 2015. From April 2014 till June 2015, not a single court, not a single judge, because of any reason, had no chance to be dismissed because there was no Supreme Council of Justice. The Supreme Council of Justice started working in July. They sent several dozens of proposals on dismissing the judges because of different reasons. And only last week these dismissals took place. So basically, it is as if the courts are to be blamed that the parliament managed to dismiss 220 judges only last Thursday. This will continue, and the Supreme Commission has an efficient procedure to dismiss the judges. The Constitutional Commission even suggests such an ground for constitution which doesn't exist anywhere in the world. We're ahead of other countries in that, how dismissal of the judge because of disability, how can it be there are efficient mechanisms which now allow to clean. There's some misunderstanding with attestation. The Council of Judges of Ukraine did not approve the documents which should become basic for assessment of judges. But these documents, which are suggested by highest qualification commission, recognized 160 amendments, 160 comments were taken into account, and only 2 are not approved. I believe that now the Congress of Judges is on the way to have it approved, but it will not take a lot of time. On the 24th of December, there will be the nearest Congress of the Judges, and there will be additionally more than 20 persons approved, and the judges do everything that depends on them. And the judges consider cases every day, but this could not be one-way road. If we are talking about reform, this should be the real reform of the society. And it's not just the public. The public does participate actively in reform, and its participation is very positive, but also political structures are to be moving in the same direction. Verkhovna Rada of Ukraine, if it really wants to implement the judicial reform, but 547 materials on appointment of judges are now considered by the Verkhovna Rada. Some of these materials have been there for more than a year, some for a year and a half. These judges receive salaries, but what we have, the administrative court of Dnipropetrovsk has the judges who have no powers to consider cases, and it's not about judicial self-governance. That is where Verkhovna Rada can demonstrate not words but actions which will be really directed towards the implementation of judicial reform. Elect the judges to who you have no questions. I remember I've been working as a judge for many years, and 20 years ago the participation of the Verkhovna Rada in the procedure of appointment of judges was of stabilization nature. They were either defending or dismissing the judges. The legislation hasn't changed in that part. But today we have the instrument of political pressure, and we cannot interpret it in any other way. Verkhovna Rada can resolve that issue today. Why don't they do it? Why are they waiting? I don't understand. And also,
Well, as a conclusion, I would like to say that, in fact, to a certain extent, this is a repetition, but it happened that judges, they cleaned up, so to say, according to the law of power, cleaning of the circles of power, lack of trust, etc. We understand that, but according to all the sociological studies, the vast majority of them tells us that 92% of respondents, they didn't have a single cases of their dealing with courts. They do not have themselves any cases of such nature, or of course this is probably not the objective understanding, but what is going on? We have mass media that is making up this standpoint, but many of them, they are dealing according to journalist code of conduct, and many of high officials, they make up certain broad understanding of that. But we do not have anywhere in the world that high official claims something that not only could not be proved. As an example, the Ministry of Justice says something about its attitude, and it insists on the fact that the majority of human rights court in EU is related to court proceedings. But please go to the website of the European Human Rights Court and look over official figures. 3/4 of the appeals related to court decisions, and only 1/4 of that other than that. So how can you say that this is related to total corruption or other crimes? Excuse me, if anybody has any information about judge that already committed a very heavy crime, then this person should either inform the law enforcement agencies, or it will be prosecuted for non-informing. Why they still, those persons, they still do not have any prosecutions against them? Yeah, we're speaking about fiscal service, executive power. The convictions sounds like this or that It's been detained, but we do not hear something like all the customs officers or all the fiscal officers or all the judges are bad. This is not true. So today we must make it more intensive, the cleaning up of the judges. But again, today we must be more. We must do this process with a higher quality and file cases against the people that having certain power responsibilities or powerful responsibilities do something wrong. And constitution is very good, we need it, but it is only a tool for I will stop you, Mr. Bogdan. Okay, if we do not have fair attitude to the law, not a single law will work in this case. Only one small comment. Please do remember that judges, this is profession with the higher reputational risks. So all the criticism in society should be considered with the use of this. Okay, we do not have that much time for next two speakers of our panel. Next, we will have time for Q&A. I should remind you that it was Bogdan Lvov, the chairman of the Supreme Court. I give floor to Democracy Reporting International, Mr. Andriy Kozlov, coordinator of the project. I understand that nobody gave any answer to the questions we are facing. We just heard certain presentations. Good morning. I would like to tackle certain issues that the previous presenter hasn't raised. First of all, we're speaking about the sociological studies. Let us take into account one psychological factor. You're speaking about 92% of people that do not trust judicial system. They never faced our court. It doesn't mean anything because they watched our courts dealing with very highly important cases. For instance, the Maidan, the court proceedings dealing with Maidan events. And this is very important because this is the making up of the people's mind. Again, the percent of people who visited courts will have much higher percentage of them that trust courts. Let us take into account that the majority of those people, they never been involved into very, say, very important cases. They were involved in certain smaller administrative cases like property-related cases, etc. So, in principle, the judicial system should probably admit the fact that everything is bad, but we have certain silver lining in that dark cloud. So, what is to be done in the framework of this constitutional reform? Firstly, the judges that were appointed for 5 years, they will finish their term, and then it will be an open competition or open tender, if you will, and there will be competition with some other candidates. Secondly, all the judges occupying their positions now should go through evaluation or, say, certification. Saying certification, we understand it will be kind of engineering approach, that will not give any opportunity to any judge to use his ties, etc., etc. So we must, first of all, judge their professional competences of judges, social position of judge. So we now have higher requirements to judge than the requirements to any other member of society or any other bureaucrat or functionary. If we're speaking about social competences, we're speaking about the ethical side of the behavior of any judge, and I would like to address the article in the Constitution that deals with the origin of property, not only judges' own property, because it's a very interesting practice in corruptioners that they shuffle their property to the members of his family or his friends, etc. And secondly, the toughest option, somebody says that this type of judicial reform does not deal with the reboot. But Venetian Commission was supported with the Constitutional Commission, and this is a European standard. The laws should be created by law. Of course, the president will exercise his power to do this, to create courts, and if you notice, the Supreme Court of Ukraine changes its name, and now it bears the name of the Supreme Court. So it's reorganization of judges. So if the courts will be made up by law, then the new judges should be appointed for such courts. I believe that not a single judge doing his job properly should not be afraid of this open competition, because he will win it. He will have another self-assurance point, because in that case he will be involved, he will be going not through the mesh of certain interests, certain people's minds, etc., but judges that will be better prepared, that will socially be more qualified. Again, we're speaking about very important institutions, but if those institutions do not have highly experienced, fair and nice people, then it is like cargo cult, where something is very similar to the genuine item but doesn't work. It means that the institutional system will not work unless the people are highly professional, and the highly professionals could not work without proper institutional system. So we must have the level of independence of judges, but we must provide, or must not, allow the system to transfer into the encapsulated mechanism of earning money. And we should remember that even delegation of powers, meaning stick and carrot, if we're speaking about the highest judicial council, and if we cut the relation between this and the president, or between this and the agency who appointed the judges, it means that the highest judicial council will not be as nice and white and shiny as we would like it. So the judicial system should comprise new judges elected by new judges. I mean new judges, not necessarily somebody who replaced somebody, but it must be a judge of absolutely new qualities. I understand that the authors of this reform strived to achieve this, but if you watch the mechanism are very precise, surgical, I would say. Once again, great request to society, please do not be tolerant to anything. So we must have all the processes, starting with the procedure of selection, next training, qualification examinations and tests. It must be controlled by society, because only in that case the processes will be transparent. That's all from me. Thank you, Andriy. The Supreme Court Judge Oleksandr Volkov, give floor to you, and next will be the word. Do I have 2 minutes or a little bit more? Probably 3 or 4. Good morning, dear colleagues. The issue of our discussion is constitutional reform in international context. The justice is a function of any state that is secured by proper state apparatus that is in the Article 6 of our Constitution. We're speaking about the governance of the state, which provide for justice for each and every member of society. Because justice is, you may settle any dispute by that or this means, but we are speaking about civilized mechanism of dealing with the disputes. As for this issue, changes to constitution dealing with justice, I have seen a lot of journalist investigations, etc. This is on fashion today, but I never saw any study devoted to the issue of the countries like China, Vietnam, Thailand, Singapore, which is economic wonder, or South Korea, that already overcame the Great Leap processes, or Georgia. What was in the beginning? Nobody pays attention to the first and immediate issue. The first step was they put their judicial system in line with international standards, independent of what is the structure of judicial system. This is the major prerequisite, the major condition of reforms in judicial and constitutional reform. So Ukraine must be put in line with international and European standards, or Article 6 of Convention, which means everybody has the right to have unbiased and fair judicial procedures or court proceedings. What constitutional changes we are speaking of? The changes should have been done yesterday, and they must be implemented quickly now, because it influences economical development of countries, social development. What is to be introduced? International standard tells that the courts must be formed by law, not politician or influences the careers of judges, but again they must build up their career by means of law. So we must introduce these standards into life, and of course something which is going on now. The Constitution of 1996. Yes, we did one step aside from Soviet approach, but the system of state governance is still in place. We are trying to break it up now, and we are now moving closer to international standards. Hopefully they will work here and they will provide for proper function of the state. What laws do we need here? First of all, my colleagues already mentioned that this process has already started.
The first thing we introduce the elements of precedent rulings or case rulings. The work continues. In the codes of procedure, we will introduce the mechanism of acting the case when we cause disputes, which ruling is better, the legal or case. But basically, unfortunately, our legislation allows to make ruling this way or that way, and it's all based on the law. We have about 97,000 regulations. How many words are there in the dictionary? Specialists, philologists, tell me. So you can find justification to any court ruling. And that is an anti-corruption mechanism when the law defines such procedure for resolving the dispute which is to be set by someone. The Constitution also states we have official interpretation of law. Now the Constitutional Court will define whether the different acts are non-constitutional. The courts are to be interpreting the rulings, and this is what is included into the notion of so-called quasi-precedent. We've been considering for many years 4 million cases by the judicial system. In all 4 million cases, up to 10 million people are involved. The citizens of Ukraine, the legal entities, the physical persons, that's a huge amount of cases. It shouldn't be like that. We are overburdening the judiciary. And because of that, the terms are delayed, the quality is bad, the system of appeal where filters are not working. This all is based on the mistakes, on all the children of war, Chernobyl victims, everyone was processed by the judiciary. Why we were doing it? That was for the money of taxpayers. There shouldn't be such organization of the judiciary. The state apparatus should be more efficient, shouldn't be so costly, because otherwise the apparatus will be not developing.
Тому, економлячи час, я те, що хотів сказати, основні такі моменти на...
Now the questions, please. Oleksandr Volkov, the judge of the Supreme Court of Ukraine. Please get involved into the discussion. You can ask questions personally to people or ask general questions. Because we started 10 minutes later, we have 20 minutes for interactive discussion. Please introduce yourselves.
На рассмотрении Печерского суда города Киева уже на протяжении 2 лет идет работа находится судебное дело гражданина Украины Глобоголовченко против Первого российского канала. Это первое исковое заявление нашего гражданина, который оспаривает ложь, созданную российской машиной агитации и пропаганды. При очевидных фактах лжи,
The microphone is not on.
поскольку суд требует у ИСА доказательств, к примеру, принадлежности официального сайта Первому каналу России. Вопрос следующий. Вот после судебной реформы будет ли проще нашим гражданам защищать свою честь и достоинство в судах Украины?
Дякую. Будь ласка, хто буде?
Yes. Just believe it. Yes.
Я Цукура Владислав Петрович.
The judge from Voroshilovsky District Court of Donetsk. Judge from ATO zone. There are many questions to these reformers. The main one is, what should people be doing? Now we will dismiss all the judges, prosecutors, other civil servants. I will tell you one news. The courts in Donetsk were the last stronghold of Ukrainian authorities. When in the city there were no militia, no prosecution, no representatives of self-government, only courts were working. So the ground floors were occupied by DPR police, militia was working, prosecution, and then courts. The fourth and the fifth floors. We were the last ones who took off our flags and took them with us. Then we had to move to the territory of Ukraine. We automatically fell into the category of corruptionists and enemies of the war, of the state. I can officially tell that I worked for 5 years in Donetsk and there was not a single pressure exercised on me. I was cancelling the ruling of the decision on the increase of communal tariffs. I had no the single case of pressure exercised on me. Do you take into account in your reforms such specific feature that in the state we have not just economic crisis but war? What should the people be doing after they are dismissed?
Виступ шановного колеги судді лише
I will provide the comment. What you say just confirms the thesis that this is wrong to totally distort the positions of the Constitutional Commission on the position and future of the judge. The Constitutional Commission was for the necessity of personal approach to assessment of the future judge. His competences, qualification are to be analyzed, the integrity of a court, the analysis of judicial practice, and in the result expressing further trust to the judge. The Constitutional Commission believes that we are against total dismissal of all the judges. We're talking about that openly. That's an important instrument. Personalization of the approach, individual approach to each judge, because that should become the basis for unbiased recognition and attitude of the society to professional activities of the judges. You're late. I started from that. I was the first speaker. So you are knocking at the open door. I started from the publications in mass media. The Prime Minister Yatsenyuk was for total dismissal. Minister of Justice Petrenko, experts of reanimation package of reforms. That is what the press says. That what they wanted to prove, I don't know. And finally, in this dispute, well, that was the question at the meeting of the Constitutional Commission. We were voting, 99% of the members of the Commission voted against that. That is absolutely objecting to the principle of the rule of law, because you are appointed on the constitutional basis. You cannot be just dismissed. That is, as Venice Commission says, it contradicts European standards because it demands the principles of independence of the judge, and that is destructive proposal. Everything that is about total dismissal, total lustration, total destruction is a destruction. That was done by Bolsheviks, by Sailov, Zalizniak, Shvondir in Bulgakov's novel. That's ruination of the state. So finally, all these who were for total destruction received the expert opinion. This cannot be done, but in order to achieve, to do what the society expects and to improve the quality of justice, yes, we need to introduce individual approach, individual assessment, qualification, and checking, verifying everything. And the journalists maybe will finally explain it to judges, because the judges believe this continues. This will not happen. Thank you, Serhiy.
Тотальне звільнення суддів, звісно ж, неможливо, тому що це
It is impossible to dismiss everyone. Even in the reform of the police, which we see that first some model cities were selected and the reform is spread. Personally to you, I bowed the head to those who were standing there with arms in hand, without arms in hand, at so difficult conditions, who were standing against the enemy. I thank you for that. I do not understand why you are concerned. If you stood against that, won't you pass this competition? Don't worry. You will come out of that in a new quality. You will be. You will understand that in this swamp you are the person who's one of the best out of the best. So I see no problem with this competition, with this assessment. Those who deserve, they will pass. Those who do not deserve, they will be doing something else, because the judge, you cannot compare the human rights and judges' rights. The judge. But those who do not pass, there's a crisis and war in the state. What will they be doing? They will have free choice to select any other profession. I'm sorry. The interpreters cannot translate you. I understand that is your pain, but we have a time limitation. 2 more questions and we will complete the discussion. If anyone else has questions, you're welcome. Judge from Kharkiv.
Mr. Lvov just mentioned very painful issues, which is idling of judges because of Ukrainian parliament, the judges that have all the necessary recommendations. The question is this a political pressure on judicial system, and what in your mind are ways of solving this problem? You didn't hear me, because that's why the constitutional changes removes all that pressure. And your colleagues will be involved in that, the highest Council of Justice. Only 2 from Parliament and 2 from President, but your colleagues, 17 of them. Your colleagues, you're professionals. It's not a political body. Even 2 members appointed by Parliament or President, again, they should have job experience in a legal profession, a law profession. That's why the reform, because of this experience, taken into notice this gap in constitution. And for 20 years it was the prerogative of Parliament. What is in your mind today the ways of solving this problem, because it is stacked? We could not solve all the problems by means of constitution. This is an issue of legislation. As for the actions of political body using political inclination to do this or that, why or by what means? By means of such event like today's event, like mass media, like communicating this to the society, etc. So the politicians, they act according to the request of society, but we must convince them to act different way. A brief remark, Mr. Bogdan. Even those discussions already happened here, they have a result. More than 200 judges have been dismissed, and because of such judges that are not dismissed, neither appointed, the state has already paid more than 200 million hryvnia in salaries. So I believe that we will have next step where not all of them, but of course we have certain criticism towards certain judges, but the majority of them, they should work. Thank you very much for everybody for your participation in this discussion. Once again, the constitutional reform in the sphere of justice is represented by Serhiy, Holovatyi, Oleksandr, Volkov, Andriy Kozlov, Bogdan, Lvov, Mykola, Onyshchuk. Thank you for attention.